I'm Steve Charkoudian. I'm a partner here at Goodwin Proctor. Okay, so what are the most common legal hurdles that I see facing startups? Really, there are three of them. First, I'd say, and this can be a real trap for the unwary, that is employer agreements with former employers. Secondly, third-party trademarks, and last, third-party patents. You want to make sure that the founding team spends time looking at any agreements that they have with their former employers to see whether the former employers have a claim to intellectual property that they were planning on being the centerpiece to the startup. So what that means is, what that can mean in those agreements is provisions like anything you do within the scope of your employment is owned by the company. Other agreements say things like anything that you do that's on company time, that's using company materials or machines in creating intellectual property or technology owned by the company, or that relates to the business of the company. The most egregious ones that I see are the ones that say that, plus they say, and it's presumed that anything that is developed within 3 months, 6 months, 9 months after you leave the company was presumed to have been conceived while you worked at the company. So as a founding team, you really want to spend time taking a look at those agreements to make sure that any former employer doesn't have a claim to the centerpiece of the technology that the company was planning on owning. On the trademark issue, I'd say you don't want to spend time, money, and effort investing in a brand if it turns out that there's a senior rights holder out there. And so you want to spend a little bit of time, at least, taking a look at, doing Google searches. You want to spend time on the USPTO website, uspto.gov. You want to take the brand that you're planning on using and do the searches there. And if anything comes back that is directly on point or frankly just related to a brand that you were planning on using, you should frankly just consider that to be knocked out and move on to something else. Last, with respect to third-party patents, I'd say similar, right? You don't want to spend a significant amount of time looking into whether there's a third-party patent that's going to block you from being able to practice, to develop your technology. But you do want to spend a little bit of time seeing if there are any particular large issues outstanding, right? So again, go to the USPTO website, uspto.gov. You're probably going to do two different kinds of searches. You're going to put sort of keyword searches that have to do with the defining nature of the product or service that you're planning on developing. You probably also want to spend a little bit of time taking a look at competitors and what patent portfolios they have. And when I say competitors, I mean anybody who's addressing the same market that you're planning on addressing. Maybe they're currently addressing it in a different way than you are. But you want to take a look to see if they've got a patent portfolio that's broader than their particular embodiment, right, that addresses the market, maybe in a way that you're planning on addressing it. So those are the three areas that I typically see can be a hurdle to an early stage technology company and ways to address them.